Hello and welcome to the View from Mayor Brown podcast. This is a fortnightly podcast series for employment lawyers and HR practitioners which highlights developments in case law and legislative changes of importance to UK employers. It is presented by Nicholas Robertson, the head of Mayor Brown's London employment team. The time spent listening to these podcasts can count towards your CPD requirements, and at the end of the podcast we will explain how to get in touch if you wish to claim CPD points or if you have any comments or questions.
Hello and welcome to podcast number 108, our first full podcast for 2017. Happy New Year to everyone, of course. With three cases this time round. The first is an EAT case on disability discrimination, which I think will worry a lot of employers. Second case is on the relevance of a final written warning followed by dismissal, where the employer subsequently dismisses the employee, but it turns out the final written warning should probably only have been a written warning. Thirdly, we have a whistleblowing case and whether or not an employee made a protected disclosure and was then subjected to a detriment for making that disclosure. As always, don't forget you can access the podcast via iTunes, Mayor Brown website, YouTube and the Twitter feed, Nicholas Robertson at Nicholas ROBER11, and that's where we put out the links for all the cases we are discussing. So, let's get underway. First one, City of York Council and Grosset. So, facts of this case. Well, the claimant was head of English at a secondary comprehensive school. It was common ground that he was disabled because he suffered from cystic fibrosis. His employer knew this. As a result of additional workload and other pressures with which he wasn't able to cope because of his disability, he became increasingly stressed. He was then dismissed after showing the film Halloween, which for those of you who don't follow these things is an 18-rated film, to a class of vulnerable 15 and 16-year-olds in an English lesson. After that he was dismissed. So he brought a claim for unfair dismissal and discrimination arising from his disability. His unfair dismissal claim was unsuccessful, but he succeeded on the disability discrimination claim. The Employment Tribunal's decision took into account the fact there was medical evidence which had not been available to his employer, which indicated there was a potential link between the misconduct in showing vulnerable pupils this film and his disability. The Employment Tribunal also decided the employer didn't have sufficient justification for the discriminatory action. As a result, overall the claimant won, because although his unfair dismissal claim was unsuccessful, he won the big one. He succeeded in the disability discrimination claim. So, a teacher shows a class of vulnerable school children an 18-rated film and wins the tribunal claim. It's almost enough to make a Daily Mail reader froth at the mouth. Anyway, and entirely unsurprisingly, the employer appealed. At the heart of it, I think, was the employer's incredulity that it could be found liable for disability discrimination when it had considered, before dismissing, whether there was a link to the disability with the employee's misconduct. And it had reasonably decided there was no link based on what it knew. But it was then found to have discriminated against the employee based on medical evidence that was only obtained by him after the dismissal. The employer also argued strongly that if it did act in a discriminatory fashion in dismissing the employee for showing this film, it was justified, and it wasn't discriminatory as a result. So, how did they get on? Well, sadly for the employers, and for employers generally, they lost on both points, and the EAT was pretty robust in its approach. It started the provisions under Section 15 of the Equality Act 2010, namely, a person, A, discriminates against a disabled person, B, if A treats B unfavourably because of something arising in consequence of B's disability, and A cannot show the treatment as a proportionate means of achieving a legitimate aim. There's a carve-out in the equality legislation dealing with lack of knowledge. Unfortunately, it merely provides that there is no disability discrimination if A shows that A did not know and could not reasonably have been expected to know that B had a disability. The legislation doesn't say anything about A didn't know that this was a consequence of a disability. The employer, unsurprisingly here, argued that the tribunal's views on disability discrimination should have been informed by the approach that the tribunal had taken on the unfair dismissal claim. For that claim, the unfair dismissal claim, the tribunal had accepted the employer had acted reasonably, and it had been reasonable for the employer to believe that there was nothing to make a link between the claimant's misconduct and his disability. Unsurprisingly, the respondent said, if it was reasonable in an unfair dismissal context, why does the same logic not apply in the disability discrimination context? Well, the EAT wasn't having this. The starting point, according to the AT, was what caused the employer to treat the employee unfavourably. The answer to that was easy. It was showing the film to the children. Was there a link between the decision by the individual to show the film and the disability? The answer was yes, there was a link, because the medical evidence which became available after the employee had dismissed the employee showed there was a potential link. The AT, in fact, had surprisingly little sympathy with the position of an employer, because the employer knew about the employee's disability. Section 15 accepts that liability may arise, subject to objective justification, once the employer treats the employee favourably because something that, as a matter of fact, on the evidence before the AT, arisen in consequence of the disability. The AT said that the lay judicial members on the AT panel, in particular, with their experience in these matters, see no unfairness in this outcome. I suspect other employers might put it slightly differently. However, I think it's also very clear that the EAT's decision is in line with the plain wording of Section 15 of the Equality Act. Once the employer knows about the disability, it's put on notice that it needs to get the next step right, i.e., if it's doing something adverse to an employee, let's say dismissal, and a link to the disability exists, then it's a straight line from that to determining there is disability discrimination unless the employer is able to show objective justification for its actions. So, how did the AT approach the Employment Tribunal's findings on objective justification? The Employment Tribunal, if you remember, had said the employer's actions in dismissing were not objectively justified. The parties agreed it was an objective test as to whether or not the employer's treatment of the employee was justified. The AT said the matter was clear that the Employment Tribunal had correctly identified the factors, carried out the balancing exercise required. In the circumstances, it was permissible to take into account the medical evidence and the impact on the claimant, and weigh that against the respondent's legitimate aims of protecting children, etc. And for the Employment Tribunal, it was able to come down in favour of the unfairness to the claimant, outweighing these factors. I should just note that we understand that the employer is seeking to appeal this case to the Court of Appeal, so it may not be the end of the story. Just like a good horror flick, there may yet be one last twist in the tale. So what does this mean for employers? Well, I think the practical answer is that you hope situations like this will arise only rarely. However, here, the employer undoubtedly feels very aggrieved and that it reasonably did not recognise there was a link, but is nonetheless penalised, without being at fault, for not realising that there was a link between the misconduct and the disability. I think the best advice has got to be that if you're acting for an employer and the employee is known to be disabled, you need to check twice, if not 3 times, whether there is a potential link to the disability, if there is misconduct. If there is, it does not mean the employer needs to tolerate whatever the underperformance or misconduct is. It means the employer needs to be very, very clear. It needs to show the treatment of the employee is objectively justified. There's no subjective band of reasonable responses or anything like that. And, to finish on a useless fact, I can tell you the Library of Congress has described Halloween as being, quote, culturally, historically or aesthetically significant. There you go. Something I certainly didn't know. Anyway, sticking with broadcast medium, next case, Bandara and British Broadcasting Corporation. This is an EAT case dealing with unfair dismissal. What does a tribunal do where the employer may have dismissed relying on an existing final written warning given to the employee beforehand, but the Employment Tribunal thinks the prior final written warning should actually only ever have been a written warning? The employee worked for many years for the BBC, and for something like the first 13 years he had an unblemished disciplinary record. However, things seemed to have gone downhill and there were clashes in the office, and in late 2013 a final written warning was imposed. That was due to stay on his file for 12 months. There were then further incidents and investigations, and in August 2014 he was summarily dismissed. He was dismissed for gross misconduct, and in the operative part of the decision, in the letter, there was no direct reference to the final written warning, which was on his file and still alive. However, earlier on in the dismissal letter, there was reference to the fact that the decision-maker had taken into account the current final written warning, and the decision-maker's evidence to the Employment Tribunal itself was that this final written warning had played a part too. The Employment Tribunal decided the final written warning had been taken into account. It felt the employer had reasonable grounds to believe the claimant had acted in the way alleged, and it found that the investigatory process was reasonable. That just left the question of, was a reasonable sanction imposed? Was it within the band of reasonable responses to dismiss the employee, potentially in reliance on the final written warning, for what he had done? The Employment Tribunal found that the prior final written warning was manifestly inappropriate. As you remember, there's a high hurdle for a claimant wanting to show that an earlier warning or final written warning should be revisited by the Employment Tribunal hearing a subsequent dismissal case. the claimant needs to show that the warning was manifestly inappropriate before it becomes relevant to the fairness of the subsequent dismissal. The Employment Tribunal, however, decided that although the final written warning was manifestly inappropriate, the dismissal was still fair. It did so by saying that if the employer had appropriately conducted the final written warning process, it would have imposed a written warning, and in those circumstances, in reliance on a written warning, the claimant's subsequent behaviour would have justified dismissal. So the question was, could an employer in effect say, yes, I know I've imposed a final written warning when I shouldn't have done so, but had I acted reasonably and imposed a written warning, then I could have dismissed reasonably for the behaviour at the end of the day. The EAT pointed out that the Employment Tribunal should start with the employer's reason for dismissal and then ask whether the employer was acting reasonably and treating that as a sufficient reason to dismiss. If the employer took into account a final written warning, the tribunal should consider that as part of its evaluation. The EAT accepted that an Employment Tribunal here was entitled to conclude that the final written warning should not have been imposed. The Employment Tribunal was also entitled to take the view that the things the claimant was being accused of in the final disciplinary process were not gross misconduct by themselves. Okay, so the EAT said the tribunal, when it had found the final written warning was manifestly inappropriate, should not have gone forward with a hypothesis of its own. It had to examine the reasoning of this employer in this unfair dismissal and test that reasoning. It was not relevant if the employer could have chosen a different way of getting to the same outcome. The EAT accepted that much would depend on the extent or the weight which the employer put on the final written warning here. Was it merely background or indicative of the standards expected of the employee? Or was it directly linked to the chain leading to dismissal? The EAT said the tribunal had not determined the extent to which the employer's reliance on the final written warning was critical in the sanction being imposed. Therefore, the case went back to the tribunal to determine the weight the employer had put on it. They pointed out as well that there would undoubtedly be findings, there would be issues about reduction in compensation, e.g. on the grounds of contributory fault. I'll say a bit more about that in a second. Fortunately, these cases are pretty rare. Employees were steered away from routine challenges to earlier disciplinary warnings by cases such as Davies and Sandwell Metropolitan Borough Council. They talk about having to show that the earlier warning was manifestly inappropriate, which is obviously a pretty high standard. However, I think this case, in an entirely logical way, does indicate that if an employer bases its decision on an earlier manifestly inappropriate warning, cannot expect the tribunal to allow it to dig itself out of difficulties by saying it could have done something more reasonable instead and still got to dismissal. In this context, I think that if an employer is faced with something which may be gross misconduct, or which may be justified but only if based on earlier warnings, the employer should think twice about whether to go just for gross misconduct or whether to rely on the earlier warnings. Indeed, it may be appropriate in many cases to say that the conduct amounts to gross misconduct by itself, but can also be coupled with the earlier warning in the alternative. I think it's also important not to overlook the fact that the tribunal did acknowledge there would be arguments on compensation open to the employer about contributory fault and Polkey reductions if the employer could have dismissed fairly. Final case, Eiger Securities, LLP and Korshunova. This is an EAT case dealing with our old favourite subject of whistleblowing. I think I probably said, and on more than one occasion on this podcast, that it's a toss-up whether this area or disability discrimination causes more practical problems for employers and for employee and employer advisors having to grapple with the subject. I think this case is no exception to that general observation. Let's make a change from our normal process, start with the law, and then talk about the facts. The Employment Rights Act 1996 sets out in section 43A that a protected disclosure includes a disclosure of information which, in the reasonable belief of the worker making the disclosure, is made in the public interest, and the disclosure tends to show that a person is failing or is likely to fail to comply with any legal obligation to which he is subject. Obviously, there are other routes by which one can get to a protected disclosure, but that's the one we're going to focus on here. Equally, under section 47b(1), a worker has a right not to be subjected to any detriment by any act or any deliberate failure to act by his employer done on the grounds that the worker has made a protected disclosure. So, in order to achieve protection, the worker needs to make a disclosure, which we'll come back to, and in the reasonable belief of the worker making that disclosure, it's also in the public interest, and it tends to show that a person has failed to comply with any legal obligation to which he is subject. Well, let's go to the facts. Claimant worked as a broker for the respondent. In connection with work, the brokers of the respondent used Bloomberg Chat to chat with traders in the firm's client banks. The respondent had a practice of sharing passwords for computers and Bloomberg Chat amongst each other. After a while, the claimant noticed that the managing director, Mr. Ashton, had on occasions conducted Bloomberg chats with a trader, ostensibly in her name and without identifying herself. On a couple of occasions when this happened, she raised with the trader concerned what had happened, and both of them expressed concern or anger about what had happened. The claimant then took to changing her password unilaterally, preventing Mr. Ashton logging in at her computer and conducting conversations. Things then go downhill. She apparently made a couple of trading errors, and one thing led to another, and she ended up being summoned to a disciplinary hearing. She was then suspended pending the outcome of that, and apparently she left, went home, turned off her screen, having apparently changed her password without authorization. She was then dismissed. She claimed that her dismissal was a result of her communicating the following to Mr. Ashton on one specific occasion when she found him at her desk logged in as her. She's recorded by the Employment Tribunal as saying to Mr. Ashton, "It's wrong for you to log in under my name when I'm not in the office and trade under my name without making it clear that it's not me who's making the trade and identifying that it is you. Yes, and my clients do not like that you talk to them pretending it's me when I'm away for lunch. At least you can say it is you to my clients next time." The tribunal upheld her claim and said she'd made a protected disclosure. She genuinely believed that what Mr. Ashton was doing was in breach of regulations, not to mislead people about who was conducting communications. The disclosure caused the respondent to take clients away from her, she alleged, and give them to trainees who were less likely to challenge Mr. Ashton's practices, and the tribunal accepted this. The appeal to the AT, for our purposes, centred on three things. First, had she made sufficient allegation of wrongdoing? Secondly, did she reasonably believe that her employer had been in breach of a legal obligation? Thirdly, had she been subjected to a detriment for having made a protected disclosure, assuming for these purposes she had in fact made a protected disclosure? The EAT accepted the tribunal had been entitled to find that there had been a disclosure of information. Again, I think the way they do it is quite instructive. If you remember, she had said it was wrong for Mr. Ashton to log in, and her clients did not like it that he talked to them pretending to be her. The EAT accepted that if she had simply said, quote, "It is wrong for you to log in under my name," unquote, that might have just been an allegation. If you remember the Cavendish-Monroe case, it's clear that an individual needs to convey some information alongside the allegation in order for there to be a disclosure. Here, she was disclosing the fact that her clients were not happy with what was happening. In the circumstances, that was capable of being a disclosure of information. However, the EAT felt the tribunal had gone wrong when it came to consider whether the claimant reasonably believed that her employer had failed to comply with its legal obligations. The EAT's decision was the tribunal did not identify the legal obligation in question, which the claimant said was breached. The tribunal found she genuinely believed that what was happening was wrong and believed there must be a legal obligation. However, the tribunal hadn't actually identified that legal obligation. Instead, it had pointed to guidance notes from the Financial Conduct Authority. The EAT said this was an error, and the case had to be remitted as a result. It was not obvious that the practice of logging on to her computer under her name was a breach of any legal obligation. The tribunal had not identified what legal obligation it was talking about. Therefore, the decision was flawed. Now, stopping there, I have to say I find this a bit difficult to follow. It's clear there doesn't actually have to be a legal obligation which is breached in order for there to be a disclosure. The question is whether the employee reasonably believes there to be a breach. In the circumstances, presumably a claimant could reasonably believe there is a breach, when in fact there is none, and therefore the Employment Tribunal would be unable, in that example, to identify a legal obligation that has been breached. Take an easy example. An employee sees a colleague being mistreated by the employer. The employee believes the employer is treating the colleague in such a way as to amount to a claim, to give rise to a claim for constructive dismissal. The employee who says this to the employer then says this to the employer, and the employer dismisses the employee who's raising the concern about the colleague. In fact, the colleague concerned has got less than 2 years' service. And yes, I know, of course, that the employee could resign and claim breach of contract and so on, but let's just focus on the statutory claim. Presumably, a tribunal would have to consider whether it was reasonable for an employee who made the whistleblowing complaint reasonably to believe that employees had a right to unfair dismissal even if they didn't have 2 years' service. Would the tribunal find there was no legal obligation that was breached because the employee did not have a claim for constructive unfair dismissal, but then consider, well, the claimant believed that such employees did, and it was reasonable or it wasn't reasonable for her to believe that. Anyway, here, the EAT remitted the case back to an employment tribunal on the basis that the employment tribunal failed to identify a legal as opposed to a moral or lesser obligation. It does seem to be a little odd. Now, nevertheless, I certainly can understand that a tribunal might want to start with whether or not there had in fact been a legal obligation breached. If in fact there was a legal obligation that was breached, in those circumstances it would obviously seem reasonable for the employee to believe that there had been a breach. Then if there was no legal obligation, the question would presumably be, was there a reasonable belief for the employee to hold that there was a legal obligation, even if it turned out there wasn't? The AT felt that despite the findings of fact by the tribunal, it also did not clearly differentiate in the findings of fact between the assumed whistleblowing disclosure and the way in which the claimant manifested her disapproval of the employer's working practices. In other words, was this a case that was similar to the Bolton case, where the employee was lawfully dismissed for breaking into the employer's system to demonstrate the breach of the data protection obligations, or was it the disclosure itself and standing up to Mr. Ashton that caused him to act in the way he did? So that case is carrying on, and obviously if it goes back up on appeal, we will bring it back to your attention. So that's it for another podcast. In an era where our post-truth world seems to get weirder and weirder every day, and I learned that you can place bets on particular words or phrases that President-elect Trump will use in his inauguration speech, I wish you all the best and look forward to speaking to you all again in 2 weeks' time. As always, it only remains for me to confirm that no Russian beds were abused or mistreated in any way during the making of this podcast. Thank you very much.
So that was our latest podcast. We hope you found it useful. If you have any questions or comments or want to know how to claim CPD points, please email Nick at nrobertson@mayorbrown.com. Our podcasts are an overview of the cases, and how the law applies in any particular case will obviously depend on the individual circumstances. So please take legal advice if any of the matters discussed are relevant to issues you are dealing with. Thanks for listening.